Hey there. Today I want to tell you about Quebec's new unconstitutional ban on school prayer and what we at the Canadian Constitution Foundation are planning to do about it. The school prayer ban is being challenged in Quebec by several groups, and we at the Canadian Constitution Foundation are planning to intervene to argue for the rights of these Quebec students for freedom of religion. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the litigation director at the Canadian Constitution Foundation, a charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in my videos is ever legal advice. If you have your own legal question or problem, consult your own lawyer. So on April 19th of this year, 2023, the Minister of Education in Quebec issued a new directive under the Quebec Education Act. And that directive requires, and I'm going to quote from it, that in each of their schools and in each of their centers, that no location is used both in fact and in appearance for the purposes of religious practices such as overt prayers or other similar practices. This regulation, to be clear, is not made under the authority of Bill 21, which is a piece of legislation you might be familiar with about secularism in the province of Quebec. It has invoked the notwithstanding clause. It requires that members of public service in Quebec not wear any religious symbols. But in this case, the directive is made under the Education Act, and there has been no invocation of the Section 33 notwithstanding clause. So this directive clearly, in my opinion, is a violation of the charter protected rights of freedom of religion of these students, and there is no use of the override. The reason this regulation seems to have been made is it seems to be because of some schools in Quebec, particularly two schools in Laval, which were allowing Muslim students to book rooms in the public schools to pray. Now, keep in mind, these were not dedicated spaces. They were just rooms that could be booked by any student for any purpose. And the Minister of Education, this came out, and the minister responded that permitting prayer rooms, even though these are just rooms that were being booked, he said that permitting them in public school is not compatible with the official policy of secularism, which in Quebec is called laicity. Now, keep in mind that this practice was to permit students to book existing rooms, not to create any special designated rooms. And it's also important to note that the directive would ban all overt prayer, including prayer in hallways or prayer outside of the classroom, like on the playground, or just anywhere where a student is, taking a knee to pray. The minister said that the directive does not prohibit prayer, though, and he said that students who do wish to pray can still do so, but they need to do so, to quote him, silently and discreetly. So the Minister of Education said, I don't want to ban prayer. I'm banning prayer in classrooms. Now, if people want to pray silently, that is their fundamental right. Well, I would assert that it is a fundamental right of citizens to practice their religion however they choose. It does not have to be silent or discreet. And in fact, the government does not get to dictate how private individuals may or may not pray. After this directive was passed, the Canadian Civil Liberties Association and a group of 5 Muslim organizations brought 2 separate applications challenging the constitutionality of the directive. Now, keep in mind that the on-the-ground facts were that this prayer ban seemed to have resulted because of the overt prayer of some Muslim students, but it is not directed at Muslim students specifically, even though they may bear a disproportionate impact because their prayer might be more overt, but it would apply to any student of any faith who chooses to pray in a way that is observable to staff at that school. So these 2 applications by the Canadian Civil Liberties Association and the Muslim organizations are brought separately. They have not yet been joined, but they probably will be joined together at some point before the hearing on the merits. And another group called Christian Legal Fellowship has also been granted intervener status in the Canadian Civil Liberties Association application. They are going to come in and add to the arguments of the CCLA that this is an unconstitutional ban on prayer, and we at the CCF would like to intervene as well, and that's what we're preparing right now. So the Canadian Civil Liberties Association's position is that this ban on prayer is a violation of the Charter 2A guarantee of freedom of religion, that it is a total prohibition on prayer, and that it can't be justified under Section 1 of the Charter. The Section 1, for those of you who are newer to the channel, Section 1 of the Charter allows the government to restrict or limit rights as long as that restriction is compatible with a free and democratic society. So the onus is on the government to justify that limit. The Canadian Civil Liberties Association is also arguing that in the event that this directive is not a total prohibition, that it's a partial prohibition on prayer, that it's still not justified under Section 1. And they're also making arguments about Section 15, which is the guarantee of equality, and specifically that the directive banning prayer is discriminatory to religious students, and that the burden falls even more disproportionately on Muslim students who pray more overtly and who actually triggered this directive. Now, I totally agree that the burden may be disproportionate on Muslim students, but it absolutely is discriminatory to religious students of any faith. So we are applying to intervene, and we have retained an exceptional criminal lawyer who's going to represent us at this intervention. We need to be granted permission from the court to intervene, and if we get permission, we are going to be arguing that the prohibition is a total prohibition and that no total prohibition can be minimally impairing. And I think that this case is just a shocking violation of the rights of students to freedom of religion. You know, the Quebec government has pushed for official secularism through Bill 21, but as I said, Bill 21 doesn't apply to the Education Act, and the notwithstanding clause hasn't been invoked. And the minister here is telling students how they may or may not pray. Now, imagine how students might feel if the government, instead of saying, you may not pray, they said you must pray, and this is how you must pray. I think that that would be seen by everyone as a really big problem, and this is a very similar situation. It's quite clearly not the role of government, and if the goal of government is secularism, the concept of a neutral state towards religion, it's simply the fact that neutrality to religion doesn't require the state to be openly hostile to the religion of private citizens, as it is in this case. And think about the practical effects of this directive on students. They are serious. Students who pray during the school day are required to leave school property. They're required to go outside in the rain and the snow to pray, even though their religious practices could be easily accommodated quite literally by doing nothing. It could be accommodated by allowing the rooms in the school to be booked for these students. The students could book them just as chess club or debate club or the LGBTQ clubs at schools are permitted to book rooms. It could be accommodated by simply doing nothing and allowing students to pray in hallways or other empty spaces as they choose. In my opinion, this total prohibition on a religious practice cannot be justified in a free and democratic society. It is targeted to children, perhaps disproportionately Muslim children. And a consequence of this directive is that religious students may simply leave the public school system rather than being prohibited from praying inside the school grounds or being forced to walk outside school property in the rain and the snow to pray outside down the block in inclement weather. The concept of secularism, of laicity of the state, of the neutrality of the state, until now, it really has been enforced on government employees, not on citizens themselves, let alone children. We are seeking to argue that this directive should be declared unconstitutional and inoperative because it unjustifiably prohibits the exercise of religion by Quebec students, and it violates their fundamental freedom of religion guaranteed in Section 2 of the Charter. And the damaging effects of this policy, forcing students to either leave the public school system or go outside in the rain and the snow, missing class, it manifestly outweighs any purported benefits like secularism inside the school. It definitely outweighs any of those benefits, and that balancing is a part of what we consider in Section 1 of the Charter. The Supreme Court has held in numerous cases that where there is a total prohibition placed on the exercise of a fundamental freedom guaranteed under Section 2 of the Charter, a limitation is much more difficult to justify under Section 1, especially under the minimal impairment and proportionate effects branches of that test in Section 1. So just to give a few examples, there's a case called Ford and Quebec, and in that case, the Supreme Court wrote that a complete prohibition on the use of languages other than French, this was a language case, on commercial signs could not meet the requirements of the proportionality test under Section 1, particularly the rational connection and minimal impairment branches. Likewise, there's another case called Multani and Commission Scolaire, and in that case, a majority of the court held that a total prohibition on ceremonial daggers for Sikh people, the ceremonial dagger of the kirpan, that a prohibition unjustifiably limited Sikh students' religious freedom. So as with the Quebec school prayer ban case, the one we're considering here, the Multani case was concerned with what was arguably a total prohibition, ostensibly in the name of promoting religious neutrality of the state in this case. In Multani, the applicant student had been willing to accept some partial restrictions on wearing the kirpan, which is the ceremonial knife that Sikh people wear. These limitations included the requirement that the kirpan was worn in a wood sheath and was sewn into his clothing. And that was key in the court's finding that the prohibition was not minimally impairing, and therefore it was not justified under Section 1. I am also of the opinion that a total prohibition on prayer in Quebec public schools won't achieve the government's stated objective of making sure that the schools, in fact and appearance, respect laicity, including the separation of church and state, religious neutrality, equality of citizens, and freedom of conscience and religion. The government could achieve those objectives in a real and substantial way through a far less drastic policy, and quite literally by doing nothing and allowing students to use empty spaces to pray. And as I've said, neutrality doesn't require the schools to be openly hostile to religion. One of the stated goals is freedom of religion. This clearly is undermining this. And the goal of secularism could still be achieved by accommodating these students. So are you surprised that Quebec implemented this policy? Do you think that it has gone too far? Do you think it's going to hurt students? And what do you think the media reaction to this story about the school prayer ban would be if it were adopted in another province other than Quebec? I think if it was adopted in Alberta instead of Quebec, we would probably have heard a lot more about it. A lot of you might be surprised to even hear that Quebec has banned prayer in schools. Now, I also did an episode of my TV show, Canadian Justice, about this situation where I interviewed Christian Legal Fellowship, who's intervening, and I interviewed the Canadian Civil Liberties Association. I will link to that show in the description below, so check it out. If you want to stay up to date with what happens in this case and with all our other cases, please check out the ccf.ca/freedom updates and sign up for our email freedom updates. That way you will know all about this case as soon as we have applied for intervener status and how this goes through the court process. And I'll continue to update you on this channel as well. But be sure to subscribe to our freedom updates because we do send a weekly update where we explain what's happening on cases like this and on all our others. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.